The judgments are in volume 5, my lord. Sub-volume 1 is the very first one of those.
From page to page 401.
So it's like a V1.
VA and VR. Volume VA, VR.
Yes,
I'm so sorry.
105.
103 old.
Yes,
Respondent PR.
yes.
Sony.
Was called to the bar on November 17, 1930, was enrolled as an advocate of the Lahore High Court on March 10, 1931. After partition, he shifted to Delhi, worked for some time as legal advisor to the custodian evacuee property. Then he practiced for some time at Delhi. He then accepted service under the Ministry of Rehabilitation as an officer on special duty and administrator Rajpura Township. On March 30, 1949, he became the chairman Jalandhar Improvement Trust. On March 6, 1949, he got his license to practice as an advocate suspended. On April 6, 1957, he was appointed as district and sessions judge while he was, my lord, the chairman of the Jalandhar Improvement Trust. So he was in the service of the union or the state or whatever it was, and he was not an advocate. In fact, he had got his license also suspended and he got appointed. So the question was whether he was eligible or not. Now, also, my lord, at page 103, top paragraph 2, Harbans Singh, he was then the deputy custodian of evacuee property when he was appointed district and sessions judge. So these two people were not lawyers, my lord. They had been lawyers earlier, but were not lawyers at the stage when they got appointed as district judges. Now, if your lordship, my lord, turns to the next page, 104.
Right. Same thing is what with respondent to Urban Singh.
That's right. That's right. That's correct, my lord. He was respondent number 3, Harbans Singh, 103 top.
And the question with regard to Justice H.R. Khanna
Yes.
was with regard to whether his practice at Lahore
Right.
should be
Correct,
taken into
correct.
consideration.
So that was a separate
completing
question.
The total
Absolutely right. Absolutely right. So that, my lord, we are not concerned with whether his practice at Lahore. That was, of course, my lord.
Now, after
Now, my lord,
the
at
only
page.
question is whether the service of Sony
Yes. And
Harbans
Harbans Singh.
as in the government,
Yes.
which was not a judicial service,
Correct.
could have been taken into consideration or not.
Not taken into consideration. When they were appointed, they were not lawyers. One of them had got his license suspended and they were working there. He was chairman of the Jalandhar Improvement Trust. Question is, are you eligible? And therefore, my lord, the question of the 233(2), either in the service or advocate of 7 years, that question therefore arose. Now, just have a look at, my lord, 104(2), 104 about. Lordship has page 104.
Yes.
About 6th line from the top. Two of them, Harbans Singh and P.R. Sawhney, did not have their names factually on the roll when they were appointed as district judges. Your Lordship has that sentence, Vinod?
Which line?
About 8th line or 7th line from the top. Two of them, Harbans Singh and P.R. Sawhney. Yes. Did not have their names factually on the roll when they were appointed as district judges because they were, my lord, working in the government.
Yes.
One of them was the chairman of the Improvement Trust. The other person was custodian of evacuee property. Now, my lord, Article 233 is quoted on that page, and immediately after 233(2) has been quoted, now the argument of learned counsel for the appellant has ranged over a wide field, but the point for decision is a narrow one and depends on whether respondents 2 to 6 fulfilled the requirements of clause 2 of Article 233 of the Constitution when they were appointed as district judges by respondent 1. Then your lordship may have, my lord, page 110.
Two and 6, they are one part, and
Yeah.
3 and 4, the other part.
I'm sorry.
2 and 6, they fall in one category,
Yes,
and 3 and 4, they fall in other category.
right, correct.
3 and 4 with regard to their experience at Lahore,
Yes.
and 2 and 6 as to whether their service can be considered.
I think, my lord, this Harbans Singh was respondent number 3 and 6. The paragraph is,
Urban Singh was number 2.
my lord, if your lordship has page 103, top of the page, respondent 3,
Number
Harbans
3.
Singh.
Respondent number 3,
Yes.
Urban Singh.
Now, if your lordship turns to page 110.
Yes.
Articles about, my lord, 10 lines from the bottom. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article
You
230.
are at page 108.
110, my lord. I'm so sorry. Because before that, my lord, the discussion is about that Lahore part. That was, we are not concerned with that. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article 233. And we do not think that Clause 2 of Article 233 can be interpreted in the light of explanations added to Article 124 and 217. Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down, and under clause 1, the governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not already in the service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. The clause does not say how that standing must be reckoned, and if an advocate of Punjab High Court, etc., then skip that part, my lord, and then come to the bottom of page 111. We now turn to the other two respondents, Harbans Singh and P.R. Sawhney, whose names were not factually on the roll of advocates at the time they were appointed as district judges. What is their position? We consider that they also fulfilled the requirement of Article 233 of the Constitution. Harbans Singh was in the service of the state at the time of his appointment, and Mr. Vishwanath Shastri, appearing for him, has submitted that Clause 2 of Article 233 did not apply. So therefore, if he was in the service, then itself he is eligible. And this was a direct recruitment, not a promotion. So that is one ground that is given by the Constitution bench. The other ground is the next sentence. We consider that even if we proceed on the footing that both these persons were recruited from the bar and their appointment has to be tested by the requirements of clause 2, we must hold that they fulfilled those requirements. They were advocates enrolled in the Lahore High Court, etc., and that their practice of 7 years would be counted. So the two grounds are given. One, that because they were in the service, therefore they fulfilled it. Because, my lord, 233(2) was read in the manner in which I am reading it. Namely, that two kinds of people are eligible. One, that those who are already in the service, and two, advocates of 7 years. So both the reasonings have been given in this judgment to not make them qualify, to not set aside their appointments. Number one, since they were in the service, they qualified. And number two, in any case, their prior experience.
No, but then, even though they were not in the judicial services.
Correct, because that plot came only by way of Chandra Mohan. Yeah, that came only later, because till then your lordship saw.
Sir, what is most important to you?
Yes.
Is observations in page 110, last 7-8 lines.
Yes. Yes. Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down. Absolutely right. Absolutely right.
But how